Hello everyone, I hope you all are doing well, taking care of yourself and your family. Before I begin with this particular session, I would request all of you to keep the barracks open with you in one or the other form while watching the video. I have already shared with you the material of all the units, unit 1, 2, 3 and 4 through a mail today, and you shall be receiving even further materials if required for any particular topic. But I have shared with you all the material of all the units, so these materials are existing in a RAR form, so you will have to unzip the folder by downloading it in your computers only, and then you will be finding the latest versions of the barracks or the laws also connected with the particular topic or of the syllabus. So would request all of you to ensure having such barracks open with you in your cell phones, or maybe any other way while watching this video, so that you can refer to the sections that we are discussing in this module or the other modules. So let's continue from what we were discussing in the previous session of deduction. So as of now we have gone through the sections till section 18, and we have seen what is a deduction and kind of authorized deductions under section 18, and the percentage of the deduction which is permissible from the wages of a worker by the employer. So I'm sorry, employee, from the wages of an employee by the employer. So let's see the further sections, or let's see some of the authorized deductions in detail which are provided in the other sections. So starting with section 19, which talks about the fines. So section 19 of Code on Wages 2019 talks about the fine. It says that we have already seen that fine is considered as an authorized deduction. So if by way of or by imposition of any fine, if any amount is being deducted from the wage of an employee, it would be considered as an authorized deduction and will not be considered as a deduction or contravention of section 18, because section 18 states that wages shall be paid without any deduction by the employer to the employee. So section 19 says that it talks about this in further details about this fine, or what are the rules or what are the ways of regulating this imposition of the fine. So section 19, first of all, it mandates the employers to specify the acts or omission on which the fines can be imposed. So the employers will have to find out the acts or the omissions, that yes, if the employee is doing this, there could be a fine which can be imposed on such employee, or if the employee is omitting to do some work, then that could be a fine which may be attracted. Now it's not only specification of such acts or omissions from the side of the employer, but that those specified acts and omissions shall be submitted to the appropriate government, and an approval shall be sought from the appropriate government or the authority established by such government from this by the employer. And once this authority or government approves such acts or omissions, that yes, these are the acts or omissions on which there needs to be a fine, and fine may be deducted from the wages of the employee, then such notices shall be by specifying such acts or omissions shall be exhibited at the workforce by the employer in a way that the employees can go through it and can understand that we should refrain from committing such acts or omitting some of the duties, or some of the what do you call regulations or the rules of the employer in the premises. So again, the section is silent about the language language of such exhibition of the notice or anything, but as we have seen in the previous labor laws and the general structure, that such exhibition of a notice should be in both the language, one in the English and one in the local language, or in the language that the majority of the workers are understanding. So such notices shall be placed in the premises and exhibited at a place from where the workers can actually read it and understand that these acts or omission should be should not be committed or omitted. Otherwise there would be some what do you call, fines may be imposed on us, maybe kind of, for example, if there is employer may say that you should refrain from eating in a particular place. Maybe it could be for the security reasons of the employees itself. So drinking water in the manufacturing places, wherein the manufacturing process is such that that spread of water would result into a greater harm, or may result into something else. So, or there could be some other omissions, right, by which the actions of the workers or the employees could be regulated, so that the security is maintained, no harm is no, there is no harm on any employee, and the premises are remaining safe for the workers who are working within. So other than this, after taking approval from the authority or the government, exhibiting the same in the form of a notice in the premises, the employer also has to give the right of being heard to the workers on whom, or the employees on whom such employer is imposing a fine. So whenever there is any commission of any act or an omission, such employee shall be given an opportunity of showing cause against such imposition of a fine, and if that cause is such that the employer finds that yes, the person was innocent and the action was innocent, then should be pardoned also by the employer. And after that, if the employer feels, after giving an opportunity of showing cause to the employee, if the employer feels that yes, there needs to be an imposition of a fine, then the employer may impose a fine on such employee by considering that the employee is guilty of committing that particular act or omitting something. Now again, the section 19 provides that the total amount of a fine in a particular wage period shall not exceed an amount which is equal to 3% of the wages payable to such employee in respect of that particular wage period. So if the employee is earning maybe 100 rupees, 3% of that 100 rupees would be maybe 30 rupees, right? So 10% is 10 rupees, of course, not whatever it is. So let's not get into the mathematics, my maths is very poor. So whatever it is, so the employer has to look after that 3%, that these fines are not exceeding 3% of the amount that has to be paid to the employee in a particular wage period, right? And so such fine shall be such, maybe if the fine is 100 rupees or 500 rupees, and if the worker is earning only 1000 rupees in a particular wage period, so then such fine would be around 10% or 50% of the wage period, the salary or the wage of that particular wage period, which is not allowed by section 19. So section 19 says yes. Section 18 says that this in the total amount of the authorized deduction should not be more than 50%. That means up to 50% it is allowed, but then section 19 says that in case of a fine, yes, it is an authorized deduction, but it should not, the total amount of this of the deduction which is being done in the account of fine or in a way of fine, it should not exceed the amount equivalent to 3% of the wage of a particular employee's wage period, a particular employee's wage of that wage or the salary or a remuneration of that particular wage period. Further, the section 19 also states that any fine should not be imposed on any employee who's an employee under the age of 15 years. So if there is maybe any botok an employee who's a child, who's again, let's not call them child, adolescent worker, we can say. So someone who's under the age of 15 years, there shall not be any fine on such what do you call such employees. Then further it says that this fines shall not be recovered by installments. Section 19 also clearly states that this fine shall be imposed in one go only. So in one salary it should be imposed, or in one particular wage period it can be imposed and can be taken, can be deducted, or can be taken by the employer, but not in the way of installment. So in a particular wage period it can be deducted, but not through different installments in different wage period. And again, it shall not be recovered by installments or after expiry of 90 days from the day of imposition. So after expiry of 90 days of the day of imposition, it should not be deducted. Now this day of imposition shall be deemed to be the day on which such act or omission has been committed or omitted. So again, there is no, this day of imposition is not the date when the employer is giving a notice to the employee that I have come across or I have got to know that you have committed this particular act or an omission. It is simply a day on which such act or omission has taken place, or it has been it has occurred in the at the workforce. It would be a date of imposition, and from that day, within 90 days, the employer has to definitely within 90 days this fine should be recovered, and again it cannot be recovered in installments. So in one particular wage period it can be recovered by the employer from the wages of the employee. Other than this, all such fines or all such realizations which are being made by the employer, it should be recorded in a muster or it should be recorded in a particular place by the employer, so that whatever the inspectors while inspectors are inspecting the premises for one or the other purposes which the authorities have for which authorities have appointed them, they can have the clear record of or clear understanding of such fines which are being imposed on the employees by the employer. Next is section 20, which talks about deductions for the absence from duty. Now, if an employee, of course, is absent from the duty or the workforce, the wages of such employee or there would be a deduction from the wages of such employee for such absence. So section 20 says that this absence from duty shall mean the absence of the employee for the whole or a part of the period during which he is required to work. So when he is required to work in a workforce, and at that moment it could be a whole part of that wage period or a part of the wage period when he has remained absent. Beyond that, it should not be considered as a absence. Maybe if, for example, if it's a last working day of a weekend, then there is a holiday. So employer should not consider that this this person was absent on the last day, so it is clubbed with even the holidays, and 2 days salary or 2 days wages shall be deducted from the wages of the employer under this as per this section. No, section 20 says that deduction for the absence from the duty can be done for the whole or part of the period during which he is required to work. When he is not required to work, if he is absent, such absence will not be considered as an absent which can attract the implementation of section 20 of Code on Wages. Other than this, section 20 says that deduction for such absence shall not be in a larger proportion than the period of absence in a particular wage period. It clearly or explicitly says that the deduction of such absence shall be only only for that particular wage which for what that person is, or for that employee is absent. So if the employee has remained absent maybe for a half day, then only half day's wages shall be deducted and not the full day's wages shall be deducted, or shall not be larger than that particular proportion of the wage period for during which that worker has remained absent from the duty. Now the proviso of section 20 provides that if in case there are 10 or more employees absent while acting in concert and are absenting themselves without any due notice or a reasonable cause, in such cases, the deductions may be imposed of an amount of wages up to 8 days of such employees' wages. Again, this is subject to the rules which are made by the appropriate government and the terms in lieu of such notices of the employers or the government. But then, in that case, the provision of Section 20 provides that if 10 or more employees by acting in concert makes themselves absent from the workforce and are not working at the workforce, because further the explanation of section 20 provides that if the employee is present in the premises but is refusing to work, that would also be considered as an absent of the worker or the employee from the workforce. So it clearly says that if in case there is no due notice or a reasonable cause shown by 10 or more persons while acting in concert remaining absent from the workforce, there could be an imposition of deduction, which could be an amount which is equal to the wages of or wages up to 8 days of such employees' wages. Other than this, we have already seen the explanation, so let's work on the next deduction, which is section 21, which is discussed in section 21, which is deduction for damage or loss. Now, of course, if any employee is being given duty or is being given a custody of goods or services, goods or some money to take account or look after that particular money or the goods, then in that case, if that employee by acting or by neglecting or by acting with some neglect or defaulting due to such negligence or default of such employee, if there is loss of such goods or money, there could be a deduction for such damage which is being suffered by the employer during the employment of such employee. So section 21 details or discusses about the same. Section 21 provides that any deduction for the damage or loss shall be made only after giving an opportunity of showing cause to the employee. So again, this is also something wherein there cannot be a deduction straight away. There should be an opportunity of being heard be given to such employees that or giving an opportunity of showing cause shall be given to such employee, and then once such cause is being shown by the employee, after considering the merits of that particular case, the employer shall take a decision that if such deduction shall be made or not. And again, section 21 provides that such deduction shall not exceed an amount of the damage or a loss which is caused to the employer by the negligence or default of the employee. So if the amount of the damage is maybe 1000 rupees, there cannot be an imposition of a deduction in a greater or a larger amount or a greater amount than the actual loss or damage that is being suffered by the employer due to this negligence or the default of the employee. And again, section 21 also, like other sections, it clearly states that all such deductions shall be recorded and shall be recorded in a register so that it can be can be inspected by the inspectors or maybe by the authorities as and when it is required. So let's just discuss some more deductions in detail in the next session. Thank you.